Welcome to Elder Care Illuminated, Torchlight's caregiving podcast. Elder Care Illuminated addresses the ins and outs and ups and downs of caring for your loved ones. Join us for interesting conversations with elder care specialists, geriatric care managers, attorneys, and ordinary people with extraordinary caregiving experiences.
Thanks for joining us for today's episode of Elder Care Illuminated. Today we are speaking with attorney Christine Boutin. Christine is an elder law attorney practicing in Massachusetts. Welcome, Christine.
Thank you, Lenore. I'm so happy to be here.
In recent programs, Elder Care Illuminated has focused on various aspects of advocacy. And today it's time to take a closer look at one of the major issues that many people face as they contemplate and complete a move to a retirement community, assisted living, or a nursing home. Whenever someone moves to a facility, there's a contract involved, and these contracts are created by the facility's attorneys to specify its terms and conditions and the rights and responsibilities of the parties to the agreement. One of the most important ways that families can help is to be aware of and part of the contract review process. So, Christine, before we start, should we be talking about so-called life care communities, assisted living, and nursing home contracts separately, or is much of what you're going to share with us applicable in all these cases?
Okay, so before we start, I do just want to state that anything that we talk about today should not be construed as provision of legal advice to any of the listeners. We are talking today about nursing home and assisted living and care community contracts, but it's in a general sense and it's just provided for information only. So now that we have that out of the way, yes. So there are certainly aspects of these contracts that are similar for all of those facilities, but there are also important differences. So I think it's important for us to talk about both.
Okay. So I'm sure you'll tell us when something's very specific to one of these kind of facilities or another. So what areas does the typical contract include?
Okay, so the one thing to keep in mind is that much of what we're going to talk about is determined by each state. So what we do here in Massachusetts and the provisions that we have for protection here in Massachusetts are going to be different in every other state. There is a federal law that governs provision of care by nursing homes, but there is no federal law that oversees either assisted living facilities or congregate care communities. So that's important to keep in mind. So you're going to have to look to your states to see what sort of protection is provided by the state where your elder lives. So I guess the biggest difference between, say, a nursing home admission contract and either an assisted living or a congregate care community contract, and by congregate care community, I mean the type of retirement living where they offer everything from independent living to assisted living to memory care assisted living to a skilled nursing unit. So they really are telling you that they're providing for all of your future needs from the time when you enter the facility until, the time when you really need 24-hour care.
Those places are called congregate care communities or life care communities or continuing care
all the same
communities. Yeah, all the same.
Yeah, all the same. So the difference really being when you enter into a nursing home, before you can even sort of contemplate admission, you have to pass a medical test to see what your level of medical and sort of daily care need is. And if you don't meet that need, you can't go to the nursing home. So pretty much when you go to, visit a nursing home, everybody there has met that level of medical and daily care need. So there's not going to be much difference between the services that everybody there is getting. They're pretty much all getting the same thing because they all need 24-hour supervised round-the-clock care. Assisted living and the congregate care communities, they're different. They provide different levels of services. So your assisted living facilities generally are going to provide assistance to people who mostly can care for themselves, but they need some help. So they need supervision of their medications, they need light housekeeping, they need laundry done, they might need some basic hygiene assistance in the apartment, they get some meals. And within that, they also have different levels of other care that they might need when we're talking about how you're meeting your daily living activities. So can you bathe yourself? Can you dress yourself? All those things. So the assisted living facility and the continuing care community are going to offer different levels of services depending on the needs of the person at the time that they apply. And different prices are going to apply to the different levels of service. So that is pretty much the basic difference, is that in a nursing home, everyone gets the same. In an assisted living facility, people will get different levels of care depending on their needs.
So Christine, does that mean that for the nursing home, it's like an all-in-one, the contract is like you're paying for everything, one
right.
fee.
Yep.
And in the other, in assisted living or in a congregate care community, the fee structure will depend upon what you're getting, or maybe it's like an a la carte menu, you pick and choose.
So different assisted living facilities and other communities are going to have different ways of writing their contracts and providing those services. So it's really important to read that contract carefully, because some of them will do a one lump sum all included. Other ones will sort of bundle in services. So there might be some services in the bundle that you need, but some that you don't, but they're going to tell you, oh, you have to buy the bundle anyway. And there's other ones that will, let you pick and choose. And also, it depends on the circumstances at the time that you're going into that facility. There might be room for negotiation, even if it is a bundled agreement. But in the nursing home, yes. So they bill by a daily rate. So within the nursing home, they're going to have different daily rates. Their private pay rate is going to be higher than the daily rate that they pay to Medicaid. But everybody on Medicaid is paying the same. And pretty much everybody on the private pay rate is paying the same. In an assisted living or a congregate care community, you're going to have people who are paying all different rates because they're getting all different levels of service.
And so I assume that room and board is set in stone in most facilities, but then you can negotiate, or that's where you're talking about the flexibility depending on what services you need. What happens if you look at the contract, you're happy with it, it suits your loved one the way he or she looks today, but maybe they're going to need more care, and pretty much everybody's going to need more care over time. Is it a new contract, or is that built into the contract?
So you have to read your contract carefully, because the contract should have built into it a provision for what's going to happen in that case. So the assisted living facility should be periodically reevaluating the elder to see, are they still at the same level of need as when they came in? Have their needs increased? So they can keep ahead of what services that elder is going to need as they age. And if the level of service has gone up, what is the price for that going to be? So you need to look at your contract to see what it says about future changes or amendments to cost. So, and be sure that it states that they have to notify you in writing by a certain amount of time before they're going to expect you to pay the increased cost. And what triggers the increased cost? Is it an evaluation? Who does the evaluation? Is it a medical provider at the facility, or is it just management that can determine, oh, well, we think this person, needs a little more, they should be paying more. So all of that is going to be in the contract. So when you are presented with this assisted living or congregate care community contract, you really need to read it very carefully, because it is going to be, the Bible for the elder's future care in that facility. That admissions contract is going to be the guideline and what everyone is going to look at to determine what the rules are for that elder staying in that facility and any changes in their needs as they age. So maybe we'll talk about this a little bit later, but one thing I do recommend is you should always have the contract reviewed by an experienced elder attorney who is in the area, and you should never just sign it on the spot. You should always take it with you and make sure that you have ample time to review it, before it's signed, because that's really important.
And I think there's a lot of pressure. The salespeople put a lot of pressure, especially in assisted living. Having gone through that with my family, they want you to sign it, and take a look at it quickly and sign it. And they will always say, that room's going to go, that room that you really like with the view of the, golf course or whatever. What are some words that people can use? Give listeners some tips of how to phrase that, or what can they say if they're feeling pressured?
You should never allow yourself to feel pressured, although that's difficult. I understand, because you're visiting the facility under difficult circumstances to start with. You should, at a minimum, not just go to one facility and say, okay, we're going to go here. You need to visit a few. You need to visit at least a minimum of 3 or 4 facilities in your area to get an idea of if they're going to be a good fit for your elder and if they're going to have the services that your elder is going to need. You should also visit at different times of the day. Visit during the daytime and you'll see full staff around. But what happens at night? You should make a visit in the evening after, the evening staff have taken over for the day, and see how well are they staffed? How many staff do you see? How well are they responding to the residents who are in the facility at the time? You should also, have a meal there. What's the food like? That's going to be a really important factor to your elder, because food is, the meals are usually communal and they're a social activity. So that's really important. You also should, consult with other family to see what their sort of feelings are, so that you don't feel that the pressure is all on you to assist the elder to go into this facility. But one thing that you can do is, you definitely can tell the facility, we have 3 other appointments scheduled at other facilities in this area, and we can't make a decision today. I would like to take the admission documents with me so I can have time to review them, because I'm really not ready to sign right now. And I need to also have them reviewed by my father's attorney, who has offered to look at them for us and give us some feedback on them. So don't ever let the facility pressure you into signing on the spot. Another thing you might want to consider is hiring a geriatric care manager to also give you some input on the assisted living facility, because they work with elders. That's all they do. They're social workers who work with the elder population. They're in and out of these facilities all the time. They network with these facilities. They know how they're run. They know which ones are well run, and they can do an assessment of your parents' needs to see if that facility, as they know it, is going to be a good fit for your parents. So all of that takes time, and that's not really something that you can do on the spot while, you're sitting in the office. And keep in mind that when you're signing up for these places, as you said, it's the sales manager. So they're not a medical team member. They're not looking at your parent to see, is this person's needs a good fit for our facility? They're just looking to sell that bed. And if it's a time when they have a low occupancy, they're really going to be pushing, because they're really going to be out there trying to get people to, come into the facility. So you might get more high pressure then. But on the flip side, that's a really good time to negotiate for a better rate.
Yeah.
So
I think those are really good points. And it's maybe cynical of me to say this, but when you're working with the salespeople, their job is sales. Right. And they may have quotas to fill, or they may have, if, like you're saying, if occupancy is low at the moment, it may be that they've got to turn the pressure on. I think the other point you make about a geriatric care manager, and having your own attorney involved means then that you've got some people that are working just for you. And there's no conflict there. They're working for you. And with that being the case, they're going to give you the straight poop, as it were.
Right.
They have no vested interest. Just as you mentioned, if you ask an attorney to review a contract, is that, typically what would that cost? And I know you've got to give us a big ballpark here, but are we talking thousands? Are we talking a couple hundred?
So given that we're talking to anybody in the country, there's rates vary greatly if you're talking to somebody who's in New York City as opposed to somebody who might be somewhere in the South or the Midwest. So that's going to be a big difference. But It shouldn't be in the thousands. Definitely should not be in the thousands to review an admission agreement to an assisted living facility. Because yes, it's a hefty agreement, but it's going to be in the hundreds, not the thousands.
Okay. Well, that's gives us a sense of where we are. So when you're looking at these contracts, are there any particular sections of the agreement that families should be especially wary of?
So there are a few. So keep in mind that these contracts are written very densely. So it is not going to be the easiest read, and you really have to take it slow and be sure that you hit every paragraph and don't skim it, because they're going to put things deep in the language that might not be to your benefit to be agreeing to. So one of the things that I just always like to bring to prospective clients' attention, and this is true for both nursing homes and assisted living and congregate care communities, is that they will put in what's called an arbitration clause. So the arbitration clause is a paragraph in your agreement that states that if there is any type of unfortunate event in the future and you have a claim against the nursing home, so say your elder was injured or harmed somewhat at the nursing home and it's allegedly due to their negligence, if you sign this arbitration clause, if your elder signs it when they're checking in, or if you're their agent under a power of attorney or a guardian or conservator and you're signing it for them, you are basically agreeing to give up your right to sue them in court. So that's big, because what you're agreeing to instead is proceeding with your claim in arbitration. And so arbitration is set up mainly to protect, some legal people see it as being set up to protect the defendant. So it's a private proceeding. It's not in it's not in a public scenario, such as a courtroom. And it's more like an administrative hearing where the rules on evidence are more lax. It's not the same as a court proceeding, and your rights are different. If you agree to arbitration, then you're agreeing to whatever the outcome is. You're going to accept that outcome, and you've given up your right to take it to a court of law. So that can make a big difference for your elder, and you really want to protect that right to bring it to court if you need to. So I always recommend to my clients that they cross out the arbitration agreement, date it, put their initials next to it, and don't sign it. And a nursing home or an assisted living cannot deny your elder the right to enter the facility because you've refused to sign the arbitration agreement. I've served as a guardian for a number of people, and I always cross them out, and they've always got into the facility. So that's never been an issue. So I that's the first thing, is I always advise my clients not to sign those. The other thing is you really need to be careful about who signs the agreement. The best case scenario is for the elder, him or herself, to sign the admission agreement. If it's family signing it, you have to be really careful that you sign it and you specify next to your signature that you are signing it using whatever authority that you legally have for the elder. So if they have done a power of attorney or a healthcare proxy and they have nominated you as the agent, you're going to sign it as, Mary Smith, agent under power of attorney for John Smith, dated, and put the date. If you are their court-appointed guardian or conservator, you're going to sign it and specify guardian for or conservative for. If you just sign your name and nothing else, then the nursing home or the facility may interpret that as meaning, they're signing this in their individual capacity. They're agreeing to be personally liable for these payments in case we don't get payments from the elder or Medicaid is denied, and we can go after this family member for private payment. So, and they will term it as, when you're looking at the signature page, they will have a line and they will either say, this is where the responsible party signs, or the guarantor, or the financial agent. And what they're really saying is, you family members sign here, and then we can go after you because you voluntarily signed it, and we are now going after you for payment. If you sign it in a certain capacity for the elder person going in, then you're not personally liable. So it's really important, if the elder is going in and they can't sign and you're not the agent, you're not the guardian or the conservator, you have to get some legal authority in order to sign for your elder. So if the time has come and they no longer have the capacity to do a power of attorney, you're going to have to go to court and get guardianship conservatorship.
That's it. That's an incredible argument for setting these things up ahead of time, because most of the time when someone is going into a nursing home or sometimes assisted living, it's a crisis situation. People don't, either there hasn't been planning done or something's happened and the person can't stay home alone. And if you don't have that power of attorney, how long would it take to get the documents taken care of?
So a guardianship or a conservatorship is a court proceeding. And so you need to get medical documentation from the person's physician first. You have to file the paperwork. You have to give notice to all of the interested parties who are family members and entitled to notice. You have to schedule a court hearing on a busy court calendar. So all of that takes time. And, certainly is not something that you would be able to do in a day or 2 days. So it's very important to make sure that your elder has done their basic estate planning documents. They have a will, they have a power of attorney, they have a healthcare proxy. Those are really important documents. Some facilities will require that the elder has a power of attorney and a healthcare proxy when they go in. They're not legally able to force them to have one, but they do strongly advise that they have those documents in place. And it's a good idea anyway. I'd also like to add that, nursing homes are, prohibited from requiring family to sign as that responsible party or that guarantor. But if you sign it voluntarily, they will say, oh, we didn't require that. They signed it voluntarily, and then try to go after you that way. So Really important. Just be careful.
I don't know how to underline things or highlight them in yellow on a podcast, but it seems like that should be underlined, that you be really, really careful of that. So the arbitration section of the agreement is one thing. Are there other typical sections that should be looked at really carefully and possibly crossed out?
So when you're looking at an assisted living or a congregate care community contract, it's going to be a long, as I said, densely written contract. And the types of things that are going to be in there are, they're going to specify, the type of room that your elder is going to be getting. Is it going to be a single room? Is it going to be a double room, a shared room? So that's going to affect the cost. So you want to check that. It's going to specify all types of things, like how many meals are included. What types of activities are they going to be able to participate in? Is there transport included if they want to take a day trip to Stop and Shop or a supermarket or something? Is there a fee for that? Exactly which health services and personal care services are going to be included in the service fee that you'll pay, which is sometimes separate from the rent. So assisted living facilities and congregate care communities, unlike nursing homes, don't usually have a full medical staff there all the time. So they will make use of, instead of having, RNs, they might have, CNAs or nursing assistants. They're not going to have the same level of staffing that a round-the-clock nursing home would have. So you want to definitely check and make sure that the kind of staffing that they can provide is going to be sufficient for what your elder needs. Because if it's not, once your elder's in there, they're going to have to pay for a home health care aide to come in. And in a nursing home, you're going to have a doctor there who's responsible for the care of the patients. In an assisted living or a congregate care, the patients are free to hire their own doctors. The facility might have a doctor that comes, or might have a, podiatrist or dentist who come every now and then, and they see patients there at the facility, but patients are free to hire their own medical care. So you want to make sure that the contract specifies what medical services are included, if any, and what's not. The other things to look out for are, what about, absences? What if you want to take your elder on vacation? How long can they be away? Are you going to be who's going to be responsible for paying the fee for that time? If it's a nursing home and your elder is coming out for a few days, you want to make sure it's specified in there that you are going to be paying for the bed, what's called a bed hold, while they're away. Because if you don't have an agreement in there that they have a bed hold, then once your elder leaves, they can discharge them and give the bed to somebody else. So you definitely want to make sure that that's specified in your contract. You also want to be clear about if there's an advance deposit that's required. A lot of congregate care communities require a substantial upfront deposit that's held, and then that's separate from the rent and the service fee that they charge to you. So you want to clarify if there is a deposit that's going to be required and what's the amount of that. What happens if you don't like your apartment that you're in the assisted living and you want to move to a new one? Make sure that that's specified. What is your right to change apartments? If you're with a roommate, say, and you don't get along and you want to move, what makes that possible? Definitely, if you leave the facility or if you pass away, when can your family get the refund? Sometimes an assisted living or a congregate care will hold on to that refund until they can resell the room to somebody else.
Is that usually specified up front in the agreement that you've signed, so that you wouldn't get the deposit back until they had rented that space?
Right. That should be in the agreement. So you want to read it. That's the section on discharge or termination or whatever the language is that they use. You want to read that very carefully to see if you did pay a deposit, what's going to happen to that money when you leave? If you're due a refund, if your elder, say, passed away halfway through the month, what are they going to do with the half they was already paid for, but, has to be returned to you? Do you have to wait until the room is rented to somebody else, or do you get it back right away? What happens if, your elder is in a situation where they cause injury to another patient, or another patient causes injury to them, or damage to personal property? Who's liable? How does the elder get reimbursed? How is that handled? So you definitely want to, all these things are going to be specified in the agreement. So that's why it's really, really important to read it carefully, because even if you're meeting with that salesperson and they say, oh, don't worry about that, we'll take care of that. If it's not written in the agreement, you can't bank on it and you can't rely on it. So you have to be really sure that the terminology that's in your agreement, that you agree and you consent to everything in there. If there's anything that you have a problem with, you have to bring it up to the facility before the agreement is signed. Once it's signed,
sounds important. You mentioned if your loved one who's in the facility hurts somebody else or made me think, does the facility carry insurance for that? I am just curious. How does that usually work?
So the facility should carry insurance, but, the issue is who's responsible for the harm to the person who got injured. And I think that it's definitely, I'm not sure that it would be the same answer for a nursing home as it would be for an assisted living or a congregate care community. But these are all questions that you want to bring up to the facility, because again, there's no federal oversight of these facilities. So There's no law that governs it. So the individual states some states do have laws that govern assisted living facilities and do have agencies that they report to. So in Massachusetts, the Executive Office of Elder Affairs is the agency that certifies assisted living facilities here in Massachusetts. So in that sense, the Office of Elder Affairs does make sure that facilities hand out disclosure agreements when you are applying, so that you know what your rights are and what the facility's rights are and where you stand, as is your rights when you enter the facility. So it's important to read that. It's not just a form. You need to, make sure that you read it thoroughly and understand, what your rights are when you enter these facilities.
You talked about termination, and you've mentioned a little bit about if your loved one dies or if they need to move. And most of the kind of termination that I think about is like 30 days, you give 30 days notice and then et cetera, et cetera. So I'm assuming that there's some typical stuff like that. And I'm thinking especially here about someone who's in memory care, is dealing with a dementia diagnosis. Some residents may become difficult as their diagnosis progresses. Does a facility have a right to terminate someone because they're hard to take care of? Does the resident have any rights given a diagnosis that might make them cranky or rude or resistant to care?
So in that sort of situation, there's some similarity between how a skilled nursing facility might handle it and an assisted living or congregate care community. So in both situations, a facility can terminate a resident for certain legitimate reasons. And those reasons are basically that, the resident's medical situation has changed and their medical needs can no longer be met at the facility. Sometimes you'll have a situation where a patient might be fine, then they have a stroke and they have a G-tube put in, and an assisted living facility doesn't have medical staff there who can attend to the G-tube sort of round the clock. So they can no longer meet the needs and the person has to go to a different type of facility.
And a G-tube is a feeding tube, right? Not through the nose, but right directly into the stomach or intestines.
Right. Sorry. Yes. Yeah. It's a stomach feeding tube. Yep.
Yeah.
So that needs constant medical supervision. So yeah, you would need to have a certain level of medical care at the facility. If they can't meet that, then they can legally discharge you. Another reason they can discharge you is if you improve and your condition gets better and you no longer meet the medical requirements to stay at the nursing home. So then they can discharge you. Another reason would be if the elder has done anything to endanger the health or safety of another resident, they can have grounds to discharge. If the elder stops paying and is in arrears on the daily payment or the rent due at the assisted living facility, they can discharge. And if the facility closes, they can discharge. So those are the legitimate reasons that either of those types of facilities can discharge a resident. a lot of times what you see is you have patients who are disruptive, who refuse medical treatment. They're just considered difficult patients in general. They fight with the other residents. They're not your docile sort of sitting down person playing the games in the, the social room. They don't do that. So they're feisty. In that type of a situation, you might find that either of those facilities might attempt to discharge a resident because they're just not the model patient. And that's not okay. So in an assisted living facility, those residents are treated as just regular tenants under our in Massachusetts, I'm talking about now. So they're treated as regular tenants under our Massachusetts landlord-tenant law. So if a assisted living facility wants to evict them, they have to go to court and fight it like just a regular landlord-tenant case. If in other states, sometimes the resident has a right to an administrative hearing. In either case, obviously, the facility has to give the resident advance notice. In a nursing home, it's a little bit different. So in a nursing home, if you often have disruptive patients or patients who refuse medications or treatment that the doctor's prescribed. So you might have, in that situation, the nursing home has to give, again, advance written notice to the patient with the reason that they're being discharged, the date of the discharge, and where the plan is for them to go upon the discharge. The patient can appeal it, but they have to do it promptly, usually within about 30 days from the notice. And the patient should definitely request the discharge plan from the nursing home, like, where do you intend to send me? And if the family and the elder feel that, this is an abusive practice, they can contact the ombudsman for the nursing home, which is sort of an independent third party who tries to mediate issues that the patient might be having at the nursing home. Or if it's egregious, the family might choose to report to the Department of Public Health, which here in Massachusetts oversees nursing homes. Now, sometimes what we see, it's really egregious, is a situation where you might have a difficult patient and the nursing home does a dump. So they take the person who's having the issues. They say, oh, this person is out of control. We're going to send them to the hospital. So they admit them to the ER. They get to the ER. They're in the hospital for a few days, and then the nursing home refuses to readmit them. I've seen that in my practice. It's not right, but, it does happen. I think to kind of avoid this, what the nursing home is supposed to do is when you have a difficult patient or somebody who's refusing treatment, they are, required to try remedies first. They have to try different therapies to see if that might ameliorate the person's behavior, change their medications, change the dosages, switch medications, see if that can improve the person's behavior, provide additional social work support, involve the family to come in for a family meeting, discuss the issues, and see if there's additional support the family can provide. These are all things that are going to help to ameliorate the situation before it gets to the point where something unfortunate might happen.
I think these are really important situations to think about ahead of time. As the feisty daughter of a feisty mother who was that patient from time to time, you want to be prepared for it. It's very painful. It's very painful. And many places nowadays are saying, especially assisted living facilities are saying, oh, we support aging in place. And I don't know if you've heard that when you talk to your clients. And in fact, in practice, they don't support aging in place because when someone is deteriorating or approaching death and there aren't services available, well, guess what? And then you're kind of high and dry, and the facility is looking to the family to remove the patient. And your goal, the family's goal, and the elder's goal all along was to be in one place, whether it was home or in the facility, and stay there through the remainder of their life. I will say that hospice can come into a facility. So the facility doesn't have to offer its own hospice service, but oftentimes you can bring in hospice. But refusal to take medications or refusal of treatment and some difficult behaviors are kind of part and parcel of someone approaching end of life. And it's important that the family be in there to support their loved one. They're not just a cranky old person that needs to be controlled. And there are, of course, on the nursing home side, rules and regulations about chemical restraint and actual physical restraint and that sort of thing. So I think an awareness of it is really, really important, in whatever it might be referred to in the contract about termination and about, I don't know, behavioral care, behavioral services, or responses to difficulties would be really important to understand before you sign. Before we wrap things up, is there anything else that you think the person contemplating working with their loved one to move into a facility should be thinking about?
Well, I just want to say a really quick word about payment. So assisted living facilities, unlike nursing homes, are pretty much pure private pay facilities. So there's not going to be any Medicaid payment at those facilities, unlike at a nursing home. So when you're going into, speaking of aging in place, if you're going into an assisted care or a congregate care community, you want to make sure that you have sufficient assets that are going to last you the anticipated time that you're going to need to be staying there. What you're trying to avoid is a situation where your elder may run out of money to continue to pay the assisted living. And so unlike a nursing home, an assisted living is not going to convert that person to mass health. They're going to say, okay, now the time has come. We need to plan for someplace else for you to go. So that can be extremely disruptive to somebody with dementia who, has lived at this one facility for several years and now all of a sudden has to leave because they can no longer afford it. So, usually an assisted living or a congregate care will sit down with the family ahead of time before the person enters and do a financial analysis to see, what's available for funds. So they know in advance if the person is going to be able to, afford the facility and not have that type of a situation. There are a very, very few assisted living facilities that do have limited Medicaid beds, but these are few and far between and hotly sought after. So you really have to be sure before your elder enters that, they are going to be able to afford where they're staying to avoid a termination for inability to pay. So I just wanted to throw that out there.
That seems like a good thing to keep in mind. I've also said, when I've talked to people about this, if your loved one's going into a nursing home and you anticipate that they will need Medicaid support in that nursing home, it's a good idea to enter with, 3, 4, 5 months of financial ability to pay. That
Absolutely.
Usually makes the transition a lot smoother than applying immediately or waiting and applying to go in as a Medicaid patient.
Right.
It smooths the transition, if that's possible for your family. So, Christine, you've given us a lot to think about. And I'm sure everyone out there eagerly anticipates reading one of these 20-page documents written by attorneys.
Of course.
It seems like a really good idea to have this type of agreement reviewed by a lawyer. Contracts can be really tricky, as you have pointed out.
Absolutely.
And that such a review would not be too expensive in most cases. And you might just head off some future problems by doing so. Listeners, thank you for joining us today. Use your skills to advocate for yourself and for your loved one, knowing that you can and do make a difference. Take care of yourselves, and we will see you soon on the next episode of Torchlight's Elder Care Illuminated podcast. Thank you. Thank you, Christine.
Thank you.
Thanks for listening to Elder Care Illuminated, a Torchlight caregiving podcast. Find other episodes of Elder Care Illuminated on iTunes, Spreaker, and Podcast Go. If you're interested in bringing Torchlight Elder or any of Torchlight's other caregiving products to your workplace, please contact info@torchlight.care. That's info@torchlight.care.